Masks are optional, but as the room grows, I think it may require.
We're live.
Morning, Thursday, April 6th, 2023. We're here this morning with Eric Patrick, who's going to walk through H 230, which is a act relating to implementing mechanisms to reduce suicide. It generally revolves around firearms. I haven't found anything else in the bill that is not firearm related. Just an observation. Eric?
Yes, good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to do a walkthrough this morning of the as passed by House version of H 230, which, as Senator Sears just indicated.
We've reached the capacity limit of the room. So I'm gonna ask that.
Do all this? How about one
No.
thing? They had offered to say they would leave if there was enough room.
No, I don't.
Oh, okay.
At least what I want to do is open the door,
Okay,
and hopefully people will be quiet out there and some can stand right near the
okay.
doorway as we do the walkthrough, and our Attorney General certainly will.
Senator Sears, would you like the rest of us to mask up?
No, I think I'm gonna leave it up to individuals.
Okay.
Since I've already contacted these. Since I've already had COVID, I'm a little more sensitive. That was a month and a half ago, so. Okay, why don't we begin the walkthrough, Eric?
Sure. So as I was saying, it's H 230, an act relating to implementing mechanisms to reduce suicide, as the chair indicated. Before we look at the language, just a quick indication of what the primary provisions of the bill are. So there's three, in addition to there's some findings in the statement of purpose, but actually a preliminary statement about that. I personally wasn't involved in the findings and statement of purpose a great deal. They were developed in the House Healthcare Committee with respect to the suicide issue. So my plan wasn't to walk through those word for word. If you decide you want to hear that, I certainly can. My focus is on the other provisions that Senator Sears mentioned, the criminal provisions related to firearms, but I can do that either way you prefer. Yeah.
You know, I've had a bias against findings ever since I've been here. I always wondered the accuracy of the findings, and here we got findings from 2016. You know, that's between the House committee, but I'd rather have you skip over the findings, assuming whoever came up with these, it's accurate. And I'd like to get whoever did the findings could come in and explain to us. I assume somebody from legislative council went over these or.
Yeah, and the sources for the findings are in the files in both House Healthcare and House Judiciary, so I can pass those along to you as well. The sources that they rely
I'd like
upon.
to know the basis of the findings. I'm not sure how much it's worth to know. The Rand Corporation research estimates that in 2016, firearms were present in 47% of Vermont homes.
Yeah, it's a policy decision for you as to whether.
Why don't we go to the part of the bill?
Right.
Yeah.
So before I get to the language, then what I want to say is the big picture. What are these three substantive pieces of the bill that have to do with the criminal law? There's three of them. One of them has to do with what's known as safe storage of firearms. So this applies when a person stores firearms on premises that are within their custody or control, and if they know or they have reason to know that a child or a person who is prohibited by law from possessing firearms is likely to gain access to it. Now, those are the preconditions. If those preconditions exist, then there's a storage requirement that kicks in on the part of the person who stores the firearms on that premises. There's only criminal penalties that apply if certain consequences occur. So in other words, if some sort of harm or illegal conduct occurs, then there are criminal penalties. There's no criminal penalties for the simple act of storing firearms out of compliance with the law. So that's one piece, the storage piece. Second piece has to do with IRPA. the extreme risk protection order. You may remember the legislature passed that in 2018. The way the system is set up, it allows the attorney general or the state's attorney to file a petition in court to obtain an order that a person relinquish dangerous weapons if having those weapons is going to be dangerous either to that person himself or to other persons. The key point in terms of what's being proposed to be changed here is that under existing law, that petition can be filed by the attorney general or the state's attorney only. The proposal here is that it allows family members or immediate household members to also file the petition. So it's based on the same structure that exists under the current relief from abuse order, which also allows family members and immediate household members to file the petition.
Let me ask a question about that. Didn't we change the law last year or the year before allowing doctors to, medical professionals, and we do something there, and did that pass? Or
It did. It didn't allow them to file directly, but your memory is correct that amendment involved allowing, because healthcare providers, you may remember, were concerned that they couldn't contact law enforcement without violating HIPAA. So the
There's an
federal
exception to HIPAA we passed.
exactly.
So what's wrong with having the household member contact police?
I think that's a policy question. I don't think there's anything wrong with it. It's a legal choice for you to make. This choice reflects that they would be able to file, but you could certainly go that route. Absolutely.
We'll point out when that bill passed, and I don't remember whether it was 178 to 0 in both chambers or 176, depends on how many House members were absent that day. But there was roll calls in both the Senate and the House on this bill that established the extreme risk protection orders, and it was unanimous in both bodies, which is, I mean, never heard of in any kind of firearm bill in this state. So, you know, I take that as something with very wide support. And when we were writing that law back a few years ago, that was one of the things that gained us the support of most folks, was that, I should say all the legislators, was the fact that we narrowed that to have a court process where the court actually had an opportunity to make a decision.
Yes, I recall that the ERPO passed unanimously, as you said, Senator Sears. And one last thing I'll mention about the proposed change to the ERPO laws. I mentioned the big picture is it allows the family or household member to file the petition, but that's only the initial petition. Afterward, the family or household member is substituted as the party who's prosecuting the action by the AG or the state's attorney. So they can permitted to file the initial petition. After that, as far as the bringing of the case after that, handling the case after that, it would be the AG or the state's attorney.
So Eric, I know we'll be walking through it, but then this doesn't really change due process. It just changes who can initiate the process.
Right. Yep, that's right. Just party who can initiate the process. And the third piece, so that's the two pieces. You've got safe storage, ERPO, and the last one is a waiting period. So there's a 72-hour waiting period created for most firearms transfers. Not all, but most. It applies whenever the firearms transfer requires a background check. And there are some exceptions to that in the existing background check law, but it doesn't fall in one of those exceptions. Then the 72-hour waiting period. So those are your three big picture substantive pieces.
Any questions about the three substantive pieces of the bill?
We'll be going further in depth on them.
Yes.
Yes, just want to give you kind of a description first of all, and then and now I can, if you prefer, Senators, I can share the screen so we can look at the language. Does that make sense?
Yeah.
Okay.
And at some point, we need to have a discussion of the constitutionality or the Braun decision and how that impacts these particular decisions.
Yes, my intention was to, after looking at the substantive language, to wrap up with a discussion of, not for the first time, so this committee remembers having looked at S4. We talked about the Bruin case before.
Yep.
But I would also touch on that again and the impact of the Bruin decision on the proposals that you have in front of you. Looks like we're getting there here. All right, so it looks like the screen's being shared successfully, so I'm going to skip over the findings and statement of purpose for now and go right to section 3, which is the secure firearm storage piece that I mentioned as being the first substantive piece of the bill. So you've got a general prohibition here in subsection 1, and this generally applies. There's a couple of preconditions you'll see in that first paragraph, A1. It applies, so in other words, it doesn't require safe storage under all circumstances. It only requires it if a couple of preconditions exist, and those are: the person keeps firearms in premises that are under a person's custody or control, that's number 1. And 2, the person knows or reasonably should know that a child or a prohibited person is likely to gain access. So those are your 2 preconditions. Child means a person is defined, you'll see when we get to the definitions. Child is someone under 18. Prohibited person means someone who is prohibited by law or by a court order from possessing firearms.
Would that include somebody that broke into my house?
So describe it. You mean if you're the owner?
Well, I
of
mean,
your
if somebody
house,
breaks into my house
right?
and I have a gun that's not, a firearm that's not,
I think that's at the bottom of the
Locked up.
page.
Not what? Sorry.
not locked.
Right.
Not following this law,
Right.
would I then be liable for having the
That's right
firearm?
at the
Line
bottom of the
20.
page.
Yeah, I was going to mention. So there's a couple of exceptions to this, and so one of those exceptions is specifically you
legal
just
entry.
mentioned legal entry or self-defense.
Okay,
So those 2, based on what you described, probably would apply.
thank you.
Yep.
How do there's house premises defined?
Premises, there's a legal definition of that generally applies to real property that's under a person's custody or control. So it's real property, in other words, not a, say, motor vehicle or something like that. Or it could be something, another structure on the real property, because it often is defined as not only a building or appurtenances there too. So it could be the building, could be the house, could be an outhouse, a tool shed, some other building that was on the property as well.
Senator Balls.
Yeah, so I know we've touched on this before, but it would be helpful for me to just like refresh my memory. The reasonably should have known would also, in my view, apply to someone who broke in, because I would have no way of reasonably knowing whether or not they should or shouldn't have a gun. Is that a correct interpretation of reasonably should have known and how it applies?
Well, in this case, the reasonably should have known applies to whether you reasonably should have known that it's in this premises, a child or a prohibited person is likely to have access. It doesn't apply to the person breaking in. You always have the defense of, hey, it was used to either defend myself or in response to a break-in.
Okay, so reasonably should have known in this instance is applying to whether or not someone can access the firearm, not whether or not they are a child or prohibited.
Yes.
Okay,
Yes.
thank you.
Exactly. Yeah. So those are the 2 kind of initial criteria that have to apply in order for have to exist in order for the safe storage requirement to apply. So then obvious questions, well, okay, if those do exist, what is the safe storage requirement? You see that in A and B, 2 basic components to it. The firearm has to be stored, A, separate from ammunition, and B, it has to be in a locked container or equipped with a tamper-resistant mechanical lock or another safety device that renders the firearm inoperable by any person other than the owner or other authorized user. Authorized user is also defined later in the statute. We'll see. So it's the owner can authorize someone to use the firearm as long as that person being authorized is not a child and is also not prohibited by law from possessing it.
Okay. Senator Hashim and then Senator Balls.
So, Eric, I just wanted to confirm. So let's say somebody has firearms in their house, they don't have a kid, and there's no one who is a prohibited person in their house. They just have their firearms unsecured. And then let's say a police officer arrives to talk about something completely unrelated, and they see the firearm unsecured. Is that person who owns that firearm, are they liable in any way?
No.
Thank you.
So only, again, as you're pointing out, it only applies if there's some reason to think that there's kids or prohibited people either living there or, could be that, let's say you have kids come to the house every Saturday or something like that. But there have to be some reason to think that they would have access. Yeah.
In the instance of authorized user, again, the language is used of, it must not be a child or a prohibited person. Am
Right.
I, the owner of the firearm, responsible to run a background check on anyone that I say, hey, you can use this? Or is it again, that reasonably should have known doctrine?
The latter.
Okay,
Yeah,
thank you.
exactly. No legal requirement that you do some sort of official background check, right?
Any other questions?
I have a question about the next piece, which is the exception. This subsection shall not apply if firearm is carried by or within such close proximity that can be readily retrieved. That language seems to me strange and a little awkward. So carried by or within such close proximity. I don't understand the by, first of all. I can't read the sentence, is carried by such close proximity.
The carried by goes down to the owner, line 17. So it's carried by the owner or another authorized person. That's one way. So the person is actually carrying it. That's one exception.
Well, no, but so this subsection shall not apply if the firearm is carried by. It can't just be if it's carried by the owner. Or you mean if it's carried on the person of the owner?
Correct.
Okay. So within such close proximity that can be readily retrieved. I understand what that's trying to do, but I'm thinking if somebody says close proximity is I have it loaded and sitting on my nightstand in my bedroom, and that's within easy reach of everywhere in the house. Is that close proximity? Because in other words, that's it seems to me when I think about the accidental shootings with children that we've seen, they all go into the parent's bedroom and pull it out of the nightstand and shoot their brother. What does close proximity mean there?
I think you're right that it's a fact question. Whether you want to work the language so that it addresses the concern that you're identifying, but I think you're right that it's intended to cover a situation where, for example, it may not be on somebody's physical person, but say you're reading and it's on the table next to you, something like that. So it's intended to cover that kind of situation. It may not be on your physical person, but it's within reach or within, so I don't think the intent is to cover any room in the house where it may be open to being visited.
Because I could see somebody defending themselves by saying, I'm in the living room, my bedroom is close proximity, I can readily retrieve the gun. So I just flagged that for later discussion. It seems to me it's and maybe in the drafting, it was a way to get over that piece that was very hard to define, but it seems like we need to drill down a little bit there.
I think that was intent, and I'm not 100% certain, but I think that the language was based on maybe some Connecticut language,
Okay.
if I remember correctly.
And maybe, is there case law supporting one reading of close proximity over another?
I'm not sure. It's a good question. That's something I can look into as well. So that segues us nicely into, so this is a defense that we've been talking about. Sorry.
Quick question, and I think I know the answer to it, but I just want to confirm it. Is there anything in this section that will require all firearm owners in the state of Vermont to purchase a safe?
No.
Okay, thank you.
And I just misspoke. I referred to that as a defense. It's an exception. So it's not a defense that the defense has to raise. It's an exception to the criminal provision. So it doesn't apply if it's either on the person or within such close proximity that can be readily retrieved and used by the owner or the other authorized user. So similarly, essentially the same practical effect. There's a couple of other exceptions. They're not called exceptions. They're called, basically stated as this conduct is not a violation. But it's the same practical effect. It means the criminal provision does not apply. And there's two more itemized instances of this. You'll see it's not a violation either if the person has a child, and we kind of referred to this earlier, Senator Spears, when you mentioned the illegal entry. So it's not a violation if the there's a child, a protected person in the house who accesses or uses the firearm either for self-defense or in response to an illegal entry. So either the owner, child, protected person uses the firearm in circumstances where it's in response to an illegal entry or as a means of self-defense, also not a violation of the statute. On to page 5, you see the penalties. Again, I mentioned earlier, there's no criminal penalties you'll see just for the failure to store your firearms properly. Even if you do have reason to know that children or protected people are in your house. See that if it's just that, and there's no other consequences, there's no criminal penalties for it. So it's a graduated system of penalties you see here based on aggravating factors. And if you don't have any of those aggravating factors, which you see in 1 and 2 on page 5, then it's not a crime. So the first one is it's a 1-year misdemeanor if the child or prohibited person gains access to the firearm and uses it in the commission of a crime or displays it in a threatening manner. So either one of those two things happen, then it's a 1-year misdemeanor.
Is there any legal definition of what constitutes displaying in a threatening manner?
Well, threatening, yes, there's a criminal threatening statute that talks about placing someone in reasonable fear of death or serious bodily injury, that kind of thing. Display, I think, is more of a would be a plain language interpretation of that. But with the threatening piece, yes.
Okay. Thank you.
Yep. So you'll see penalty number 2, 5-year felony, much more serious, again, graduated system. And this, so it becomes a 5-year felony if the child or prohibited person gains access and they use it to cause death or serious bodily injury to any person. So again, the more severe the consequence, the more severe the penalty. Moving on, subsection C, this is a charging discretion piece. That is
Don't they have charging discretion at all times?
yes, I think it's
So why is this here?
I think it's one of those situations where sometimes the legislature wants to highlight a particular policy. And I agree that it doesn't change the law. They have discretion as it is.
And why doesn't the Attorney General have that charging discretion too?
Oh, that's a fair point. Right.
No discretion for the attorney.
I guess they don't.
Yeah, that's the
If we're going to do that, I think we should add if the majority of the committee decides to go in this direction, I think that the Attorney General should also have charging discretion.
That certainly makes sense to me.
Doesn't mean we're gonna do it.
right. If you do. Yeah, you wouldn't want it to be one of those situations that I don't get the Latin. Si unio exclusio, something like that. The inclusion of one thing means the exclusion of another. So
Yeah.
you're inadvertently excluding the AG from charging discretion. Probably not your intent. All right.
Well, since he's right here, I thought I'd raise it. Yeah.
But as you pointed out, Senator Sears, yes, that charging discretion certainly exists already, and it's just that sorry.
I wanted to understand in all of this and the direction this is going, isn't this true already? That if something horrible happens, the state attorney could charge somebody with neglect, child endangerment. There's all kinds of crimes that can be committed if a child gains access to a firearm and something horrible happens. I was under the impression that we have those laws on the books.
I think it is possible, but it's a matter of, the facts of a particular case as to whether or not an existing criminal provision, like you mentioned, may or may not apply. I think this makes it clear in a way that current law doesn't. But again, whether to have a policy decision can be.
No, but as I look at this charging discretion, it's also true that the state attorney will charge under another provisional law or the attorney general.
Yeah, they had the right facts.
And in the case, and particularly in the case where you have a cause death or serious bodily injury, the state attorney may find that 5,000 in 5 years isn't enough. They want to charge higher.
Yeah, as I said, it depends on the facts, whether or not some other existing crime might apply. So that's a charging discretion piece, just, if if it's violated and the person who violates is the parent or guardian of the child who uses it, in unintentional or self-inflicted injury, then there's discretion. It says they may take those facts into consideration when deciding whether to file criminal charges. So now you have an information distribution piece. This is subsection D, bottom of page 5. This essentially applies to federally licensed firearms dealers, FFLs, federal firearms licensees. That's federal law requires that firearms be sold by FFLs. In the facility, essentially, the place where the sale is made, this essentially creates a posting requirement so that the FFL must post a sign where they conduct the sale, and basically the sign has to describe the legal requirements for safe storage in Vermont. Again, it sort of assumes that the bill is passed, right? Because the bill itself is what contains the safe storage requirement. So the two things are connected. It has to describe that, and it has to describe risks of having firearms in the home. So the detail of the language basically talks about where the signs have to be located, where in the licensee's place of business they have to be located, the contents, what has to be in the warning. I'm over on to page 6 now. What the typeface has to be, so it's pretty specific. And then the warning itself, you'll see also on page 6. I assume you guys have line numbers on your versions, right?
Yeah.
So we have the contents of the warning itself starts at line 8 and goes through line 18. So you see it's verbatim that the warning has to require, the warning must contain the language that you see in front of you on page 6. And the first paragraph after the capitalized warning describes the risks of having firearms in the home. And the second paragraph that starts with Vermont law requires, that describes the legal requirements for safe storage. That would be the case if the safe storage piece of the bill passes.
Who helped to develop this language for this sign? Was that simply legislative council? Did you work with, and the reason I ask is just thinking about disability access and thinking about, the best way to convey information around mental health stuff. So I'm just wondering if you worked with my bright community partners, or if this is just legal language.
I'm going to defer to, I understand, I think the sponsor of the bill is coming in later
Okay.
this morning. I think that would be a question best
Okay,
directed there.
thank you.
Yep. The definition section, we've referred to some of these already. So this goes over on page 7. You'll see the authorized user I mentioned earlier, because remember the person whose premises it is can also authorize someone else to use the firearm, just indicates they have to be 18 or up. And not a prohibited person. Child is person under 18. Firearm and licensed dealers, definitions you've seen many times. A lock container, if you recall, that's a definition of what an actual lock container has to be. That's in the provision that requires that under certain circumstances. Means box, case, chest, locker, safe, or other similar receptacle equipped with a tamper-resistant lock. Prohibited person I mentioned earlier, state or federal law or court order prohibits them from possessing firearms. And serious bodily injury is something that's been in the law for a long time as well. So that's the end of the safe storage piece. I can pause there for a moment before moving on to the ERPO section.
Well, I do have a general question about the advertising or the notice. Where else do we do that?
There are a couple of other places, and I remember drafting them over the years. I can't off the top of my head remember exactly where they are, but I can look that up for you, Simon.
Telling private business what they're going to advertise and where they're going to advertise.
Well, we did hospitals.
Right.
We required a notice that
So firearms can't be brought on the premises.
The only thing that comes to mind when I think of that is cigarettes, that we
Yeah.
require a label.
And
But we don't, the federal government.
Right. We do on cannabis, though, require some labeling about the potential health impacts.
Senator,
So a question, if few questions on constitutionality and on this section by itself. And if there's some things you can't answer, I understand. But if this section 3 were to be challenged by itself, what would the standard of review be for it? Or do you know, or would you be able to describe?
Yeah, you mean under the Second Amendment?
Yeah.
Yeah, it goes back to the Bruin standard, so that we've talked about before, and I can jump into that right now. Maybe that'd be helpful to go right to sort of a discussion of constitutionality.
Yeah, I just have a quick question, Eric. Under section 3, A1 prohibition, you stated that there's no criminal offense for not storing your firearm or whatever else within the household, correct? It's only after the fact?
Only if some certain other consequences occur, right?
So, I mean, I think storing your firearm in a safe location is just common sense. However, I guess we need to make laws to tell people that. So, so the intent of this bill really doesn't accomplish anything other than issuing a warning to those individuals who do not store their guns safely. The act in itself could possibly still quite happen, right?
If the act happens and there's no use of the firearm to cause death or injury to somebody, if none of those other things happen, then you're right, it's not a crime.
No, what I'm saying, it's not going to prevent this from happening simply by creating this law warning gun owners that they must store their gun in a safe location, separate from ammunition.
I don't know the answer to that, what effect it's gonna have.
Do you mean, Bob, that you're saying that you think it should be a crime if they don't store it securely and somebody notices that, even if there's not the ensuing?
Well, I'm not saying it should be a crime because I don't know how it's going to be enforceable. However, what I'm saying is the language in this bill says that it's not a crime not to do it. But if an unauthorized person gains access to a firearm,
Right.
and they do commit a crime, this is nothing more than a warning to the gun owner, say, well, you know, put your gun in the safe storage facility. We could charge you down there. Also, it's doing nothing on its ground values to prevent this from happening. In fact, I mean, it's common sense. You should do this, but where's the teeth in this other than a warning to the gun?
I mean, I would think that the liability of being charged criminally is definitely a deterrence to keeping your firearms out unsecured if you have kids or prohibited people. I mean, you know, we have speed limits. People
Those are all
follow the speed
adhered
limits.
to.
They're what?
And those are all adhered to.
Yeah.
Obviously.
And so, you know, I mean, people don't speed because they know there's probably a trooper up the road who might write them a ticket if they're speeding. Same thing here.
Well, I'm not saying it's good or bad. Losing the life of anybody is going to be a bad thing. All I'm saying is the purpose of this doesn't seem to be accomplishing anything. It's not a criminal act. Losing the life of a loved one because you didn't do this, which is common sense in my mind. But this is nothing more than a warning to say, lock your guns up and store them separately, or, you know, such as you were saying, Senator Hashim, that you could be charged. If that's the only deterrent we're looking for, then fine.
Yeah, I think it's, and correct me if I'm wrong, but it seems like this version has probably evolved to make it more palatable in states where they didn't want to do a flat out legal prohibition of having a weapon in your house that wasn't secured. So it's evolved away from that to more an emphasis on preventing the consequence, the person who shouldn't have the gun or the child getting it. So you're only charged criminally in that case. So I take the point that there could be a stronger version of the bill, but I think there are also other things here, like having it not kick in unless it's out of somebody's immediate control. That's obviously a compromise too, where you're trying to lean toward allowing the gun owner to use it in a manner that's lawful and constitutional and not going to create a problem. But I think you're right. In a purely logical way, you would make the act of storing the weapon unsecured itself illegal.
I think it's similar to the seatbelt law. Unless you're doing something else, they can't give you a ticket.
And not primary enforcement.
Okay. And Senator Wells.
Yeah, no, I certainly, you know, my read on this and sort of my understanding of other states that have moved in the direction of safe storage is this is a much more conservative approach. And I think there are policy decisions to be made if we want to stand in that more conservative space. But I do agree with Senator Hashim that most people, this is sort of that reminder that, hey, if something bad happens, I am now liable, I'll store my gun securely. And while as a gun owner myself, I certainly secure my firearm and think that it's common sense. Unfortunately, the tragedies we've seen in the world point to the fact that it isn't common sense for everyone. So I hear you, and perhaps it is too conservative, I don't know, but it's a balancing act.
I'll just add there at the end that Senator Bruce kind of alluded to this, that the bill as introduced on the House side did include that provision. So it did include a provision that it's made it unlawful regardless of the consequences, which is more like, to pick one example, there's a variety of approaches in different states. For example, Massachusetts takes that approach. Ultimately, through the committee process, they removed that piece and only kept the prohibitions for situations where this consequences occur. And that's more of an approach like New Hampshire and Maine take.
And just to clarify, I've often heard that we're the only New England state without some version of child access protection. Is that true?
I'm not sure off the top of my head about Connecticut, Rhode Island, the other ones. It's a good question. Yeah.
I had a nod from the background.
Okay, right.
One of the experts. Yeah.
I have just one more question, and this is sort of about what, and this may be better directed at the sponsor of the bill, but just kind of what happened in the House. Was there any conversation in looking at safe storage around also incentivizing homeowners insurance to sort of add both a carrot and a stick, to sort of say, like, you know, we will grant you a discount in homeowners insurance if you are safely securing your guns, and if you're not? Did that come up at all?
Not while I was there.
Okay.
I wasn't there for all the testimony either, so it could have come up when I wasn't present, but I don't recall.
Let's move on. We've got quite a few wetlands.
Right.
So let's move on to the section on extreme risk protection orders.
Yes, I'll jump right there. I just wanted to finish up because Senator Hashim had asked the question about the constitutional standard, and it's up there on this. I put it on the screen for a moment. So that's a quote from the Bruin decision, that what the new standard is. And, luckily, it doesn't always say the standard is, but it actually does in this case. So when the Second Amendment's plain text covers an individual's conduct, that means essentially that when it implicates the right to self-defense, which is the core Second Amendment right in the Supreme Court's analysis, then the Constitution presumptively protects that conduct. That means there's a presumption that it's unconstitutional. And that shifts the burden to the state to prove that it isn't. And how do they do that? Look at the second sentence. The government must then justify its regulation, excuse me, by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. So that's the historical analysis that you probably recall we talked a lot about in the historic context.
So my follow-up to that is that when we are creating policy regarding this, it has to be narrowly tailored and specific, right? It can't just be broad when it comes to the Second Amendment.
Not sure. You mean the language itself, or?
Yes, the language.
I think, you know, the question of what's going to satisfy this historical tradition test is very much open, especially in the Second Circuit, which is the federal circuit that we're in. I'd say in general, it's very much open, and I was going to sort of close things by talking about why it's even more open than many other legal questions at the moment, all kinds of reasons for that. I can get to that now or kind of close up with it.
Well, I know we want to move forward to other sections, so maybe we can revisit it.
Sure.
Thank you.
Sure. So, Senator Sears, as you mentioned, the next section is the ERPO section, Extreme Risk Protection Order. I'm just going to move the screen to that piece. Let's see. Yeah, here it is. That's section 4. So you may recall, as Senator Sears, you were alluding to this, the ERPO law was passed in 2018, Act 97. It was based on the existing state RFA law, the Relief from Abuse Order provision in state law, as well as on some other state ERPOs that were in existence at the time. It allows the state's attorney or the attorney general to file a petition in court seeking an order that prohibits a person from purchasing or receiving a dangerous weapon. The court will grant that petition if it finds that there's evidence that the person poses an extreme risk of causing harm to themselves or another person by having a dangerous weapon. Now, remember, there's two types of those orders. There's an emergency ex parte order and there's a final order. The emergency ex parte order only lasts for 14 days maximum. The standard there is preponderance of the evidence. So the person only has to show by a preponderance, more likely than not, the person's a risk to themselves or others. But that can only last for 14 days. And there's a final order that has a maximum period of 6 months. That's got a clear and convincing evidence standard attached to that. So that's the existing process. But remember, as I mentioned, it's only the AG or the state's attorney that can file this petition. The proposal here that was passed in H 230 is to allow family members or household members to file that initial petition as well. This is also already permitted in the RFA statute. And at least with respect to household members, because the key point here is, well, how do you define these terms, right? Who's a family member, who's a household member? With respect to household members, the RFA statute has a definition already. And this language that you see at the bottom of page 7 is essentially identical to the household member definition in the RFA statute with one primary substantive change. And that's that you'll see that everything is referred to in the present tense. Household member means persons who are living together, are sharing occupancy of the dwelling, are engaged in a sexual relationship, or minors or adults who are dating, right? The RFA statute applies in the past tense as well, are or who have in the past, right? So are living together or who have lived together, so are sharing occupancy or have lived together, are sharing occupancy.
So Eric, if two people are living together, they break up and it's an acrimonious breakup and one moves out and a week later, one of them applies for an order, is that no longer present tense?
Correct. So I would read that as that person would not have standing.
So what was the policy choice in the House to make it present tense as opposed to replicating the verb structure that was in the other part of the law?
I think they just wanted, their preference was to have it be a more narrow class of persons to.
Because it's, when I think about these kind of conflicts, it's often the case that somebody has moved out, broken up, et cetera. And if it's literally present tense, like, are you at this moment living with them as opposed to last month or whatever, I think that would take out a lot of at-risk folk. Anyway, I'll flag that.
Yep.
Yeah, I additionally would like to flag that. I mean, the statistics actually show that the most dangerous time in an abusive relationship is once the person has left the relationship. So I feel like not only are we taking out some, we're actually eliminating this protection for the most significant group of people. So thank you for that flag.
Let me ask a question from the other side. So father takes daughter's cell phone because she's been abusing it or whatever reason. And you're not gonna have your cell phone for a week. Daughter calls and files, I'm gonna get your guns taken away. What's to prevent that happening for 14 days under this scenario?
Well, it would, the
I mean, who in the court at 10 o'clock at night decides the veracity of the charges?
I think you're right, that there's going to be some evidentiary support to the charges, and that it'll be a good question for Judge Zone as to who's going to be the person who sort of receives these incoming calls.
I'll go back to the original law. That was the comfort level of having the state's attorney or the attorney general making a determination of the veracity of the charges or the allegations. And, I would not have a problem if doctors and other healthcare professionals that are working with somebody who's going through a mental health care crisis were able to afford themselves that. But I am concerned about, getting back at something. That's one of the reasons we felt like the family member can call the police. The police can call the state attorney or attorney general. work that way. Anyway, let you continue the talk. Senator Mahalski.
I think Senator Sheen actually had his hand up first.
Could you just remind me again, the evidence standards and then also, actually, yeah, just what were the evidence standards? One more time?
So for the emergency petition, the 14 days preponderance, so it's more likely than not. Whereas the 6 month, the final order is clear and convincing. Although remember that the, we haven't got to it yet, but I mentioned this at the beginning. Although the family member or household member can file the initial petition, they're going to be substituted. This requires that they be substituted as the party to bring the action later on.
I'm only concerned with the initial.
Yes, exactly.
That's my concern is the initial,
An initial call.
because the judge or whomever magistrate is getting the call at 10 p.m. We're not getting the call and we're not going to court under the RFA. That's the model they're using.
Yes, that's right, under the RFA. That's his model.
In an instance, and I don't really know the whole process. So if this were to pass and a family member files the initial petition,
Right.
that doesn't guarantee that it is granted, correct?
Correct. Has to meet the standard.
The
that someone
evidentiary
shows
standard.
Danger to
Well, that's
themselves.
why I think I'm gonna wait for Judge Zone or State Attorneys to ask the question about what happens at 10 o'clock at night.
Well, so my follow-up question to that, currently we're relying on the police. So the person calls the police take time to get there. They then reach out to a state's attorney or attorney general. My concern is just the speed in which these types of things happen. They're usually not hours and hours and hours. They tend to be rash, instantaneous decisions. And I worry about like the length of that process in protecting someone, or what we've heard in some of our other testimony for the individuals in domestic violence situations who don't feel comfortable calling the police because perhaps they also have a substance use disorder, or perhaps they have historically not been served well by police. So I want to flag, obviously probably most of this bill is going to end up with flags on it from all of us, but I just want to flag that as something to sort of process
But
through.
this doesn't affect the domestic violence cases that are going for an RFA. So it's modeled on that process, but
It's a different section.
it's a different section. Senator,
Somebody's getting an emergency RFA, they have to show that there's a risk of imminent harm, right? Or is there,
They have to show that they were a victim of abuse, and I think that there was potential for further abuse, I believe.
and if somebody were to lie, just to get back at somebody else, is that a crime?
Actually, I think it is. I think there's a provision and specifically makes that illegal. And I think now that I'll double check it, I think the same provision is also in this ERCO statute as well.
Thank you.
So, actually, last real quick, family member. So you see, there's no definition of family member here. Specifically, there's also no definition of family member in the RFA statute. However, the Vermont Supreme Court specifically issued a decision and defined family member for purposes of the RFA statute, so would apply here as well. And they defined it to mean a person related by blood, affinity, or law. So any blood relation, affinity is an in-law, or any legal relation as well. So blood, affinity, or law, family member under the Vermont Supreme Court case law. The next couple of pages really, so that's the big picture of what's going on in the ERCO. You'll see that in a couple of places where necessary, like page 8, lines 8 and 9, family or household member is added, because that's the proposal here, to add them as a person who can bring the action. The point I mentioned about the substitution of the party, after the initial petition is filed, the party becomes the state's attorney of the AG. That's the bottom of page 8. They become the new person who brings the action, and the total on the top of page 9, the family or household member is no longer a party. After that, you see that in line 2, after the substitution. Also requires subdivision 2 requires the court to send copy of the documents in the case to the state's attorney and the attorney general. And that's all for the final order. You were just looking at that section. The emergency order section is the next one, so you see the same language in the emergency order section over on page 10. That the court has to send the documents to the SA of the AG, and the family or household members substituted in that section as well.
Wow, I just realized that there's a gun show. Loophole
Exception.
built into the waiting.
There is an exception for gun shows to, has a sunset, a 1-year sunset, but as a sort of initial point first, about to move to the waiting period piece, unless there's any other questions on the ERCO. So as Senator Ruth was saying, the waiting period piece starts at the bottom of page 10. This basically requires most firearms transfers to have a waiting period of 72 hours before the transfer can be completed. Basically, if it requires a background check, that's the kind of transfer that requires a background check, then the 72-hour waiting period would apply also. You may recall from the background check law that there's some exemptions, for example, law enforcement, military, immediate family members, so those don't require background checks, so they also would not require a waiting period. You may also recall last year in Act 87, you passed an additional 7-day essentially default proceed. You know, federal law's got that 3-day default proceed. If the FFL, the firearms dealer, doesn't get an answer back from NICS, the National Instant Criminal Background Check, within 3 business days, then the firearms transfer can proceed. And that's called the default proceed. You passed the state law last year, increasing that to 7 days. So if they don't get an answer within 7 days, they can still proceed with the transfer.
Right.
But
we passed it at 30 days.
it's 7 business days though,
Right.
so it's 10 calendar.
And
Right.
the governor vetoed it.
Oh, that's right. Yeah, initially 30 was vetoed. That's right.
So that, this doesn't do anything to close the Charleston loop.
No, this doesn't address that.
I mean, we closed it by a quarter,
Yes.
28.
Right. There's a reference to it, though, in the bottom of page 10 over on the top of page 11, because you'll see that it adds a 3-day waiting period, but it's 3 days or 7 business days have elapsed since the dealer contacted NICS, whichever occurs earlier. So the idea is that the goal is not to add 3 days onto the 7 days. So it's 7 days max. See what I mean?
The military exemption from the background check, is that active duty military?
Let's see. I can look that up for you. I don't have that right in front of me, but I will definitely follow up.
Where is this?
Well, it's a cross ref. It's
It's a cross-reference.
yes. So it's not actually in the language in front of you, the specifics of how that military exemption works. But I'll look that up.
Thank you.
You bet.
Go ahead.
Eric, I was also wondering about online purchases for section 7. And I just want to make sure that the 72 hours is getting to the heart of what this bill is supposed to accomplish. And so by way of example, a few years ago, I purchased a firearm online. It took about 2 weeks to arrive, which, is fine. That's how the mailing goes. When it comes to the purpose of this bill, though, it's obviously 2 weeks pass. I go to the firearms dealer to pick up the firearm. I would have to wait another 3 days after having waited 2 weeks, correct? If this moves forward.
I read it as 3 days from the date of the background check. So I don't know how that works online, but whenever your background check was completed successfully and they got an answer that said, this purchase is okay, that's when the 3-day clock starts.
Because it gives them a number.
Gives them a number when you do the purchase.
And so that would start when I went to the FFL to pick it up after having ordered it. That's, I think, something worth discussing later on. Yeah.
While we're on it, I'm just gonna point out that a few years back, we passed 24 hours in the Senate. didn't get to the governor, as I recall.
No, he
One of the-
vetoed it.
Pardon?
He vetoed it.
He vetoed it. Okay, thank you for that.
Yeah.
And one of the reasons we settled on 24 hours, I'm not gonna argue about the number of days here, but one of the reasons we settled on 24 hours, we had people come in and testify who had done a number of studies on suicide. And the evidence was that most people make those decisions on an impulse, and that 24 hours was in the high range in terms of the impulsive act of buying a firearm and going out. And that, I don't know where they came up with 72 versus 48 or 24 or, 7 days like I think it's California stuff. Were you involved in that discussion?
I think it was just the nature of the legislative process back and forth.
But I'm going back to that evidence. It was a group from Harvard, as I recall.
Yeah, these two experts, Tim Ash brought in.
Right.
So my
No, I
understanding.
didn't want to comment on that.
I had a question also, but
Oh, so my understanding, and this is just from my knowledge as a mental health professional, this is a suicide prevention bill, and we have in statute, I believe it's 18 VSA, but I'm not going to get the exact cross-reference, the allowance for someone who is a danger to themselves or others to be involuntarily held for up to 72 hours without a court order in the hospital. So we've taken away their physical freedom. So for me, this language simply lines up with existing mental health law meant to protect people and the public. For me, it was like, obviously at 72 hours, that's exactly what we do in other instances where someone is a danger to themselves or others. So I just wanted to put that.
Two things. One about the 24-hour bill that the governor vetoed. I think it's important to note that in his veto message, the governor pointed out that there was not substantial research around 24 hours. And he listed that as one of the reasons he was vetoing it. So we thought we were presenting him with something he would find more palatable, but he used that as one of the reasons to veto it. So in my way of thinking, he may not have intended that, but he's in essence asking us to go where the research is, which is around 72 hours, most of it. The other thing I would ask here is, Eric, on the bottom of page 11, so there's the sunset for the subsection.
Correct.
I'm used to seeing sunsets in the effective date section. And I don't remember seeing one where we repeal, and maybe I've just blipped out on them, but where we repeal a subsection, because it seems like you could wind up with confusion because there's a lot of, sub. So I'm assuming that this applies to E1 and following.
Correct. That's a subsection. 1, 2, and A and B are subdivisions. So yes, in response to your question, it is actually done sometimes. And so if let's say that this were to follow through and it actually did happen and no changes were made, it's repealed in a year, you would see that year in the supplement, the statute would be repeated, and where E says there would be a brackets and it would say repealed.
Right. Okay. I guess speaking for myself, I think it would be better to have it clearer, like a separate section that was going to be repealed, or it just it feels a little confusing to me the way it's presented. But then in terms of why they did it, I'm assuming this is to allow gun shows to get the word and plans that are in operation for the coming year to go through so that everybody's given, I mean, like we did in S55, we had a sunset on competitions with high capacity magazines. Was the thinking in the House that this allows people time to run through plans that they've already laid for that year?
I think that's part of it, but also, and I don't know if Representative Lalonde is going to be testifying, or one of the other members of the House Judiciary, but I think one of their goals here was to ultimately get to a place where a person that the background check would not apply to someone who already owns firearms. And so in other words, it's not in here. But the idea here is for now, have a gun show exemption, presumption being that people that purchase gun shows in many instances already own firearms. And then going forward, there would be possible legislation next year, and this is what was discussed in committee, about coming up with a way to define and put in statute the exemption from the background check for someone who already owns one.
I think that would be crazy, but that's just me.
Are there any statistics around whether or not someone who purchased a firearm from a gun show is more likely to already own a firearm? Where did that presumption come from?
It was discussed in committee, but I'm not sure about whether there are actual statistics in existence about that, but that'd be a good question for witnesses.
Okay, thank you.
Is any of this constitutional? I think that's the next issue.
An excellent question, Senator Sears, one which I will remind everyone about.
You've already given away the secret.
And I'll also remind everyone
But
that
nobody knows for sure.
nothing is not consistent from when I testified with respect to S4. And so just to remind everybody of what that we already went through, what the standard is from Bruin, it's highlighted in bold. And by the way, this document Peggy posted, so you all have it. It's posted today, so you can always refer to it. This is a review I did of Bruin as well as the implications going forward based on the language and the holdings. So, but just so you can review it at any time on your own, but just to remind us, and really, I think in response to your question, Senator Sears, you're going to hear other witnesses, I think, testify that these proposals are either definitely constitutional or they're definitely unconstitutional. And some of those witnesses are going to end up being proven correct. And some of them are going to end up being incorrect. I don't know which is which at this point in time. And in my view, the
We
only.
should go to Washington and ask.
Right, that could be.
Justice, which one?
We may end up there.
Yes, and maybe sooner rather than later, because one of these cases may go up.
I have a question about the phrase historical tradition.
Mm-hmm.
So, history extends to the past moment, you know what I mean? And goes all the way back to recorded history. So it's unclear to me, and it has been ever since the Bruin decision, in what sense they mean the historical tradition, because the historical tradition lots of times shows an evolution on an issue to, greater understanding, greater safety, greater efficacy, et cetera. And we change as we go through. So if you look at the history of, regulation of automobiles, it's, you go back to the beginning, there weren't any. And then we have added lots of regulations to make driving safer and more efficient. So when I think about the way they're trying to use that test, it has to sit with the historical tradition. So there are laws, for instance, that have been in place for 100 years. New York had a law that was challenged under Bruin. Is there one sort or moment in the historical tradition that's privileged over another? In other words, is the court saying that something that was or wasn't in place in the 18th century is privileged over something that has 50 years of tradition now? You see what I'm saying? Is there any further guidance in Bruin around how to define the historical tradition? And does it allow for the fact that as history moves forward, we, in almost every other field, we think about in a kind of evolutionary way that we're changing to better our use of the law?
Right.
Any thoughts on that?
Definitely. So when I answer the question, why is this so unclear going forward? In my view, why do I take such a strong position that it really is a situation where it's almost impossible to predict where the courts are going to go? There's three main reasons for that. One of them is the one that you're identifying right now, having to do with the when of the historical tradition. So if I'll skip right to that, or since you asked it, I'll skip right to that second question, which is the when. You see that what time period in history should be compared? And the court did, so the bold language is from Broome. They're set to say, look, the moment that they're talking about is what did people understand when the constitutional provision was adopted, right? In this case, the Second Amendment. That's the moment in history that's key. Constitutional rights are enshrined with the scope. In other words, how much scope does it have? They were understood to have when people adopted them. However, this also goes to why there's an ambiguity, why there's a piece that's impossible to predict, because the Second Amendment, although it was adopted in 1791, was not incorporated against the states until the 14th Amendment was passed in 1868. So you've got two different historical periods. And the court in Broome specifically left open the question of which period is the one you're supposed to look at. There's some language about what may be more important because it's closer in time to 1791, but they left it open. Justice Conan Barrett, in her concurring opinion, specifically noted that we left this question open. So, and even you see right there in the bold language, they acknowledge there's this ongoing debate over whether courts should primarily rely on the understanding in 1868 or 1791. And you may think, well, that's sort of is that really going to make a difference? Yes, is the answer. That will make a difference. For example, just a couple of weeks ago, the United States Court of Appeals for the 11th Circuit just came down with this decision. It's had to address that exact question because the issue was Florida's law prohibiting possession of firearms by under 21s constitutional under Broome. And as it happens, there isn't a lot specific about prohibiting underage people from possessing firearms in 1791. In fact, maybe the opposite, because of the militia provisions that allowed people of that age to be in the militia. Sometimes they didn't require it. But as you got further along in the 19th century, more and more states passed these laws that prohibited underage people from possessing. So the court had to decide, and it concluded, you see the quoted language right there, the more appropriate barometer is the public understanding of the right when the states ratified the 14th Amendment. That's 1868, and made the Second Amendment applicable to the states. So for that reason, the court said, look, the laws restricting firearms possession that were passed during the 1800s, they're relevant. And therefore, this Florida statute that prohibited firearms possession by under 21s is constitutional under Broome. So that's a big decision. Only a couple of weeks ago, I'm only aware so far of 2 circuit courts of appeal that have analyzed Broome in depth and come to a conclusion. This one upheld an under 21 age restriction from Florida. The 5th Circuit Court of Appeals struck down the federal prohibition on persons subject to domestic violence restraining orders from possessing firearms.
Because they used the
Unconstitutional.
1791.
That one was more of a, they were looking at, okay, thank you for that segue. We'll segue right back into the other unopened question. To them, and that they did comment that laws more close to the time of 1791 were the better to look at. They didn't address the issue quite so expressly, but they did say, yes, closer in time, 1791 is the one to look at. But more importantly for the 5th Circuit is this other open question is, what is it to be consistent, right? Look at that, the language here, second bolded line. The regulation has to be consistent with the nation's historical tradition of firearm regulation. So what is consistent? And they talk about that a little bit in Bruin. And they say that Heller test today requires, and this is Bruin, to assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. This historical inquiry that courts must conduct will often involve reasoning by analogy. A commonplace task for any lawyer or judge, like all analogical reasoning, determining whether a historical regulation is a proper analog for a distinctly modern firearm regulation. Some historical laws that analogous enough requires a determination of whether the 2 regulations are relevantly similar. Is it relevantly similar or not? To be clear, analogical reasoning under the Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. On the one hand, courts should not uphold every modern law that remotely resembles a historical analog, because doing so risks endorsing outliers that our ancestors have never accepted. On the other hand, analogical reasoning requires only that the government identify a well-established and representative historical analog, not a historical twin. So even if a modern day regulation is not a dead ringer for historical precursors, still must be analogous enough to pass constitutional muster. How much is enough? How relevant is relevant enough? What level of generality is permissible? Because it have to be exactly the same? Well, the court says no, it doesn't have to be a twin, but it has to be somewhat the same. That's very, very difficult to figure out, and it's going to vary on the individual circumstances. So this goes to your point about the 5th Circuit decision on the prohibition by domestic violence restraining orders, they said, because there are these colonial area laws that disarm people that are dangerous and disloyal. And they said that's not relevantly similar enough. So with them, with that court, in other words, it wasn't a question so much of timing as it was this, how similar is it?
Right.
Um,
But I mean, I'm laughing because it feels to me like the Bruin decision just, it is so, it's straining so hard to accomplish a certain end that it adopts these sort of strange, it basically allows a court or a judge to do whatever they want. They say that you have to have a historical analog, and yet it can cover weapons that weren't conceived of at the time in history. So it seems like they build in contradictions that allow a court to go in whatever direction they please, although making sure that most of them will be on the pro-gun rights side. So anyway, my ongoing trouble with Bruin.
I recognize you're not a constitutional scholar, but I wonder, so around safe storage specifically, it's my understanding that between the 1700s and the mid 1900s, there's over almost 200 instances of safe storage law in the history from varying different municipalities, including, like I'm looking at one right there from 1894 from Rutland, Vermont. And I mean, is that enough to be a historical analog? It seems like clear and convincing evidence to me that there is a historical analog, but I'm wondering what your thoughts are, given that you're a lawyer and I'm a social worker.
Well, first of all, I'd say that 1894, so it's unclear whether that would even be relevant under Bruin.
Well, and I mean, I'm looking at another one from 1909 from New Mexico. I'm looking at one from 1783 from Boston. I mean, it's a range from the
Right.
mid 1700s to the mid 1900s. So maybe 1894 doesn't apply, but where is Vermont? I know you just said it, but where's the year mark that they say?
1791 is for Second Amendment, and then I think 1864 for incorporation. So those are your two kind of operative time periods. But in response to your question, even sort of beyond the time period, I think it really is going to depend on, how, in other words, are those safe storage laws, are they general requirements that apply to all firearms? Are they, it's how it's sort of the answer is in the details. How close are they and that sort of thing? And that's going to be a case-by-case decision.
Okay.
All right,
Last thing I'd say is just that, well, first of all, there's two decisions, the Fifth Circuit and 11th Circuit decisions. It's interesting that I've read them both, and they're both extremely well written. They're very well reasoned. They support their arguments very well. And they reach different conclusions about how to apply Bruin. So to me, that's just an interesting observation because they're both very well done. And to me, that indicates that, and the Fifth Circuit, I should add, the United States has already filed a petition for writ of certiorari, which it's not unusual for that to be granted when a circuit court finds a federal law unconstitutional, which the Fifth Circuit did. So maybe we'll get an answer sooner rather than later about it. But it does indicate that I think both those decisions read together, both well thought out. Supreme Court's probably going to have to do some clarification.
okay. Eric, thank you very much.
Yes,
for
thank
the
you.
thorough walkthrough and for the constitutional analysis.
Sure.
And our next
Let me
witness,
just,
final witness before the break.
I'm going to try.
We're gonna get backed up here, and so I'm warning ahead of time, and Peggy, we will have other people come back next week who we don't get to today. But our next witness is Jerry Clark, Vermont Attorney General, and who would have to defend this if it became law.
Thank you.
Maybe I'll rephrase that. Her office would need to defend that.
You what?
Your office would need to
Yes.
defend this if it
That's right.
became law and it was deemed unconstitutional.
That's right.
Charity Clark, Attorney General, very happy to be here and also happy to be here for Legislative Council. That's always very helpful. I have brought with me today two lawyers from my office, a constitutional expert, Ben Battles, who is our Chief of the General Counsel and Administrative Law Division, who has been involved with the litigation over legislation this body has previously passed related to guns. And also Domenica Pajula, who's the chief of our criminal division. So if anyone wants to get in the weeds or ask questions that Eric couldn't answer and I couldn't answer, they're here to be helpful. There's a lot to say, but I do have some specific suggestions for changes. Before I tuck in, I just want to make sure to be clear for the record that we support this bill, urge this committee to pass it out, and urge the Senate to pass it out. It's a strong bill and will save lives, and I won't hesitate to defend it if that comes to pass. We have a couple of changes that I think will make the bill a little stronger. So I know you guys are looking to move things along. So let me just tuck right in. I'm going to also skip the findings and go right to the purpose. The legislative purpose section, we had actually made a small suggested edit in the House, but it was kind of toward the end of their process. I talked with Representative Lalonde to ask why they didn't make it in, and that was the indication that I had. So currently it has, the purpose of this legislation is to prevent death by suicide by reducing access to lethal means of firearms. Our edit is more specific to reflect what's actually going on in the bill, which is to prevent death by suicide by reducing access by children and prohibited persons to operable firearms. And I, of course, can pass this language on to Peggy to make things easier.
I was just gonna say that the sentence as it stands is extremely awkward, so I would be happy to see him.
I've been dying over it. This is my former English professor, so I'm dying over his like because I have the same instincts. It's so funny. Oh
Small
my
world in Vermont.
gosh. Of course.
Quick question for you, Charity. Preventing death by suicide, should there also be, and preventing other violent crimes as well? Because, you know, I know that it's not just suicide that this bill can prevent. I mean, if somebody in the heat of the moment decides they, in a domestic dispute, that they want to hurt their partner and they go to purchase a firearm, but they have no intention of hurting themselves, that waiting period could prevent that. So, and I know this is just the purpose section, but I feel like this bill can also affect things that aren't just suicide. So.
Yeah, that's a good point. I mean, I would leave that to you all, but it's a good point. It does do more than just suicide. I guess it's the suicide prevention bill, so maybe that's why the emphasis on the suicide in the purpose section. Okay, I'm not going to go into the constitutionality unless you want me to. I felt very comfortable with the conversation. Well, actually, no, I am going to weigh in. I want to say, I think Eric was completely right to say that there is some unknowns. This is a very fresh decision. However, what we're doing here and have been doing in this this session is to make sure that this bill is the best bill that we can come up with to meet the criteria that we know exists from the Supreme Court on how to comply with the Second Amendment. I mean, the beauty of having a new decision is we just get more clarity on how to comply with the requirements to have a gun safety bill that is constitutional. So we have Heller, we have Bruin, that gives us more instruction on how to comply. That's the way that I look at it. So that being said, let's just, I think this is easier for me to just tick through here. Okay, so I wanted to note on page 4, this section 4024, there's the exception for self-defense. And I anticipate that you might hear later from people who aren't as supportive of this bill that the safe storage provision is unconstitutional because of Heller. And I wanted to emphasize this exception is designed, I presume, to make sure that this section does comply with Heller. which means Heller said there was no exception in that case for self-defense. And here there is an exception for self-defense. So just wanted to flag that for you. That's meant to counteract the problem in the law that was being the subject of the Heller decision. So there it is. Wanted to flag it for you. Let's talk about turning the page, the charging discretion section. We would just delete. I was appreciating the chair's observation there. And then skipping ahead to the extreme risk protection order section. We're a little concerned about the process. So walking through the steps, if, well, the section is, so it's 4053, no, it's 4054.
Page 9.
Yeah, page 9, yes, page 9. Oh, wait, am I skipping this? Sorry. Okay, no, it's page 8. So under 4053 sub B2, so this is the procedure. So a family member or household member has taken that first step, and then the state's attorney or attorney general shall be substituted. As we know, the attorney general and state's attorneys have concurrent jurisdiction, which is a great system. This is actually, I think, a little confusing, cumbersome, and may cause problems to have it be either or. So we would recommend that it be the state's attorney. The attorney general has their own ability to bring these. I don't know that it's necessary that we're here. I just think it would streamline the procedure to make it clear and expedient to make sure this gets done. So that would be one suggestion there. And let me make sure I didn't forget anything. Oh, I did forget something. So in 4024, let me see where is that? Okay. 1A, 1B. In a locked container or equipped with a tamper-resistant mechanical lock or other safety device properly engaged, this next phrase is what I have trouble with. So as to render the firearm inoperable by any person other than the owner or authorized user. Wondering if we might just end the sentence with properly engaged, because when you unpack this sentence, to render the firearm inoperable by any person other than the owner or authorized user, I am concerned that alignment of facts about, you know, does that mean you need to have like a fingerprinting mechanism to unlock it? That's you, your person. It's a little cumbersome, and I think you don't lose anything by just ending the sentence earlier. Properly engaged, meaning this, whatever the safety device is being used properly. So those are our suggestions, and obviously we're happy to answer questions, or if you want to tuck into one area in particular or have concerns after the testimony about one area, Ben or Domenica or I are happy to come back.
So my question regarding the 72 hours, do you feel, or do any of your colleagues feel that there's a substantial enough body of evidence to say that 72 hours is more effective than 48 hours or 24 hours?
You mean a legal sense or the suicide prevention? Because we didn't really look.
Either one.
Yeah, I mean,
or if you want to get back to me.
Yeah, I mean, 72 hours resonates with me. I'm not the expert on suicide prevention. I'm more the legal person, so yeah. I don't want to weigh in on that without any evidence to back it up. But in my own personal reading of things, that seems to be the effective time frame and the recommended time frame. I've supported that actually when I was campaigning. So
awesome. Thank you.
Yeah.
Yeah, from a legal standpoint, does it make it easier to defend in that it aligns with existing mental health protection law? does it not matter?
I don't know. I'll have to think about that.
Okay.
I don't know that it needs to align. It's neat. I like harmony in the law, but I'll think about it.
Okay.
Other questions for the Attorney General and any other of her? I thank you very much. I mean, do you have any concern about the process under the ROCO,
Under the what?
extreme risk protection order
No.
sections?
No, other than the one I mentioned, that it's just a little cumbersome with the either or language, I don't.
Thank you.
All right, thank you.
We're gonna take a break until 10:45.